Hello, everyone, and welcome to Internet Law Review. For today's story, we have the case of Fourth Estate versus WallStreet.com. This is a case dealing with copyright law and when a copyright becomes effective. There had been a dispute in the lower courts as to the time a copyright became operative. Some courts had held that a copyright became applicable once it was applied for, while others said that it only became valid once it was actually granted by the Copyright Office. In this case, the Supreme Court is asked to resolve this split, so let's see what the issue is and see what the Supreme Court had to say. Let's get started. Petitioner Fourth Estate Public Benefit Corporation, a news organization, licensed works to respondent Wall Street, a news website. Fourth Estate sued Wall Street and its owner for copyright infringement of news articles that Wall Street failed to remove from its website after canceling the party's license agreement. Fourth Estate had filed applications to register the articles with the Copyright Office, but the Register of Copyrights had not acted on those applications. Title 17 of the United States Code, Section 411, states that no civil action for infringement of copyright in any United States work shall be instituted until registration of the copyright claim has been made in accordance with this title. The District Court dismissed the complaint, and the 11th Circuit affirmed, holding that the registration has not been made under Section 411 until the Copyright Office registers the copyright. Held. Registration occurs, and a copyright claimant may commence an infringement suit when the Copyright Officer registers a copyright. Upon registration of the copyright, however, a copyright owner can recover for infringement that occurred both before and after the registration. Under the Copyright Act of 1976 as amended, a copyright author gains exclusive rights in her work immediately upon the work's creation. A copyright owner may institute a civil action for infringement of those exclusive rights, but generally only after complying with the requirement that registration has been made. Registration is thus akin to an administrative exhaustion requirement that the owner must satisfy before suing to enforce ownership rights. So under federal law, but not necessarily under state law, there is something called the exhaustion doctrine, which basically says that you have to exhaust all your administrative or other remedies before going to court. The idea behind this doctrine is fairly simple. If there is someone in an administrative capacity who can grant you relief, then we go through that course of action first. Only once there is a final position from the person ultimately in charge should we then go to court, because the court should only act once the administrative process has failed. And that's what they're talking about in the exhaustion doctrine. So basically, the United States Supreme Court is saying that the registration requirement is of the same type as this exhaustion principle. Only after you've exhausted the administrative remedy, in this case by getting it registered, can you then go to court to sue on that property. In limited circumstance, copyright owners may file an infringement suit before undertaking registration. For example, a copyright owner who is preparing to distribute a work of a type vulnerable to pre-distribution infringement, for example, a movie or musical composition, may apply to the Copyright Office for pre-registration. A copyright owner may also sue for infringement of a live broadcast before registration has been made. Outside of statutory exceptions not applicable here, however, the statute bars a copyright owner from suing for infringement until registration has been made. Fourth Circuit advances the application approach to this provision, arguing that registration occurs when a copyright owner submits a proper application for registration. Wall Street advocates the registration approach, urging that registration occurs only when the Copyright Office grants registration of the copyright. The registration approach reflects the only satisfactory reading of the section's text. Read together, the statute's first two sentences focus an action by the Copyright Office, namely, its registration or refusal to register a copyright claim. If application alone suffice to make registration, the section's second sentence, which permits a copyright claimant to file suit when the registrar has refused the application, would be superfluous. Similarly, the third sentence, which allows the registrar to become a party to the action with respect to the issue of registrability of the copyright claim, would be negated if an infringement suit could be filed and resolved before the registrars acted on the application. The registration approach reading of the statute is supported by other provisions of the Copyright Act. In particular, the section confirms that application is discrete from and precedes registration, while another statute's pre-registration option would have little utility if a completed application sufficed to make the registration. Fourth Estate primarily contends that the Copyright Act uses the phrases make registration and registration has been made to describe submissions by the copyright owner. Fourth Estate therefore submits that the statute's requirement that registration has been made in accordance with this title most likely refers to a copyright owner's compliance with the statutory requirements for registration of applications. Fourth Estate points to other Copyright Act provisions that appear to use the phrase make registration or one of its variants to describe what a copyright claimant does. Fourth Estate acknowledges, however, that determining how the Copyright Act uses the word registration in a particular provision requires examining the specific context in which the term is used. The specific context of the section permits only one sensible reading, that the phrase registration has been made refers to the Copyright Office Act granting registration, not the copyright claimant's request for registration. Fourth Estate's contrary reading stems in part from its misapprehension of the significance of certain sections of the 1976 revision to the Copyright Act. But by enacting this section, Congress both reaffirmed the general rule that registration must precede an infringement suit and added an exception in that provision's second sentence to cover instances in which registration is refused. That exception would have no work to do if Congress intended the 1976 revisions to clarify that copyright claimant may sue immediately upon applying for registration. Noteworthy too, in the years following the 1976 revisions, Congress resisted efforts to eliminate the section at bar, which contains the registration requirement. Fourth Estate also argues that because registration is not a condition of copyright protection, the statute should not bar a copyright claimant from enforcing that protection in court once she has applied for registration. But the Copyright Act safeguards copyright owners by vesting them with exclusive rights upon creation of their works and prohibiting infringement from that point forward. To recover for such infringement, copyright owners must simply apply for registration and await the registrar's decision. Further, Congress has authorized pre-registration infringement suits with respect to works vulnerable to pre-distribution infringement, and Fourth Estate's fear that a copyright owner might lose the ability to enforce her rights entirely is overstated. True, registration processing times today have increased from 1 to 2 weeks in 1956 to many months today. Delays, in large part, are the result of the Copyright Office staffing and budgetary shortages that Congress can alleviate, but the courts cannot cure. Unfortunate as the current administrative lag may be, that factor does not allow this court to reverse the section's congressionally composed text. The notorious Justice Ginsburg writing on behalf of a unanimous Supreme Court. So that is the story of Fourth Estate versus WallStreet.com. A fairly simple statutory read, and no surprise that the United States Supreme Court came to a unanimous conclusion. There are provisions of law that give people the right to sue before registration, and if registration occurred immediately upon filing, then those provisions would be inoperative. And the Supreme Court does not like to read a law that causes other parts of the law to disappear. We look for things to be a unanimous whole wherever possible. So it makes sense to say that in most instances, a person must gain registration, that is, actual registration by the Registrar of Copyrights, before filing suit, for the exceptions to make any sense, and that is exactly what the Supreme Court said here today. But for now, my friends, this is all. I hope you're well, and until later, cheers and goodbye.